Meeting is now called to order. And the first item on your agenda is the administration of your oaths of office. So if everyone will step right up here at the corner of the dais. I'm going to hand you your oath so that you can read it, and then we will sign them later. They're not in alphabetical anymore because I have to use them in already. You must be Mr. Dove. I believe you're the only one I haven't met. I'm Jane. Yeah.
Mm-hmm. Yeah.
Okay, so everybody else gather up here close to me. And Shannon, put your left hand on the Bible. And repeat, I'm gonna say I, and then you're gonna say your name, and then I'll read each line and you can repeat that to me. I do solemnly swear that I will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina, not inconsistent therewith, and that I will faithfully discharge the duties of my office as a member of Hope Mills Board of Adjustment, so help me God.
We get a picture. We get a picture like this way.
Hold on, please.
Nah.
Can y'all kind of spread it out?
Yeah, get on the line.
Okay.
Mason, I'll take some pictures.
Here we go. People in the front. God, I've never been short.
Y'all ready?
Okay.
Thank you.
Thank you.
No.
Now, if y'all want to have
Yeah,
a seat up
have
there.
a seat up there, and we'll put the nameplates out for you. Just wherever you like.
We just sit back there.
Alternates can sit up there for at least for the
There's room
training.
for everybody to sit up
Yeah.
there. There's 7 seats.
Yeah, you can go up there. Then we'll just put the nameplates out.
Yes.
Yes.
I will need you, everyone to sign their oath and give it back to me.
I got a pen right here. So. I'll still go for it.
Give it to her. Yeah.
Remarks complete.
Thank you. Okay.
They're actually on. So. Thank you, sir.
I'll make sure she gets it. Thank you, Brian. Okay.
We grab this, Melvin, put it down there for me. Thank you.
I wanted the seat with the gavel.
Oh, that's it.
You were drawn to it.
Again.
Water.
Nope. There's one in there. I stole his stuff.
Is there a pen?
Sorry.
I got a highlighter. Can I steal your pen really quick?
Oh, yes, sure.
I'm sorry, I'm Joanne Scarola. Hey, Joanne.
Just, you can hand me back this at the end of the meeting.
All right. First, I'd like to welcome you guys to the new Board of Adjustment. My name is Chancellor McLaughlin. I'm the Development and Planning Administrator for the Town of Hope Mills. I'll be your main point of contact for all things Board of Adjustments, variances, special use permits, agendas, packet preparation, and things of that nature. I'd now like to turn the floor over to our attorney, Mr. Dan Hartzog, who will lead the training for the Board of Adjustment. Thank you.
Hey, how are y'all doing? First of all, thank you all for agreeing to serve on the Board of Adjustment. We very much appreciate y'all's time and the attention that you've already given to this. I know I sent y'all some materials from the School of Government to look over about sort of how the board functions and what the legal parameters are, and I hope everybody's had a chance to review all that. As we go through this training tonight, I absolutely want y'all to jump in with questions if you have any, because this is a great opportunity for us to sort of get all the ground rules in place before we actually have a hearing at 6 o'clock. So any questions that y'all have as we go through this, please feel free to interrupt me and ask them. Y'all have a copy, I believe, in front of you of the actual Board of Adjustment ordinance. If y'all recall, the Board of Commissioners has recently amended this to name y'all as a citizen board. And when you just took the oath about following the law, this is really the law that y'all are going to be applying, is this Board of Adjustment ordinance, which is really modeled on the North Carolina General Statutes on Board of Adjustments. So this is really the key document for y'all, is this Board of Adjustment ordinance, and we'll sort of go through this piece by piece. But that's the document that you need to be familiar with as members of the Board of Adjustment. So as it starts out with the establishment of the Board of Adjustment, up here, I think this is actually an old slide. Thought we had got that updated, but the only thing different is still consists of 5 members. Now, instead of consisting of the 5 commissioners, it's appointed by the 5 commissioners. So y'all are appointed by the Board of Commissioners. And instead of Mayor Pro Tem serving as the chairman, y'all at the next meeting, this is just the training, so at the next meeting at 6 o'clock will be your first formal meeting as the Board of Adjustment. You'll need to elect from among yourselves the chairperson to preside over the meeting. And town clerk will serve as secretary and keep the minutes. And if legal questions come up during the hearing, I'll be here to help guide us through any legal issues that might arise. So y'all only meet on an as-needed basis. You don't have regular meetings or anything like that. It's only when someone asks for something that is done by the Board of Adjustment, like a variance or something like that. And when we have something that the Board of Adjustment needs to hear, we'll contact y'all and try to get a time that everyone can be here. So you'll just meet on an as-needed basis, probably not every month, maybe once every 2 months, something like that is usually how it's been. Let's see. So the big thing to keep in mind as a Board of Adjustment is every decision that y'all make is what's called a quasi-judicial decision. What that means is y'all are acting as essentially a judge. You're taking in the facts as presented by the applicant, and you're applying the law, this ordinance, to those facts. So what you're doing is acting kind of like a judge does. You hear the evidence and you make a legal decision based on that evidence. Does it comply with what the requirements are to grant a special use permit or a variance or whatever it may be? Because it's quasi-judicial, it's very important that you build the record and you only make the decision based on what the record contains. So I told all of y'all ahead of time, don't make any decisions or don't look at anything prior to the actual hearing, because whatever decision y'all make at the end of any hearing is got to be based on the evidence presented at the hearing, which means documents given to you, testimony given by the witnesses, anything that you happen to know that you come into the meeting and you say, well, I know this wasn't said, but I happen to know, A, B, C, that can't be considered. You have to base it only on what is presented at the hearing. So the 4 types of things that y'all are going to be hearing as the Board of Adjustment. The first is appeals. Town staff, the planning department, and chancellor, sometimes things come in where a decision is made with respect to a zoning issue. And if the person who is the recipient of that zoning decision doesn't like it, they can appeal to y'all as the Board of Adjustment. And y'all will take a look at the evidence and decide if the right decision was made. That So an appeal is really just looking at what was done and deciding if the right decision was made or the wrong decision was made. A variance. Variance is where technically the person who's applying for a variance does not meet the requirements of the ordinance, of the zoning ordinance. But what they're asking for is a variance. What they're asking for is, I know I don't meet the criteria for this particular, use of property, but I'm asking for y'all to make an exception for me. And we'll go through the requirements of what you need to show to have a variance. But that's what that is. It's, I don't meet the technical specifications of this ordinance, but can y'all make an exception for me? Special use permits is sort of a particular piece of property wants to do a certain thing on that property. If it's not something they're already permitted to do under the current zoning, they can get a special use permit, and we'll talk about that. And then the last thing is interpretations. This is really just, where there's a dispute on map lines or boundaries, other similar questions of a zoning issue. Y'all might be called upon to make an interpretation of what the correct reading is. All right. So logistically, how do you conduct the hearing? First of all, like I said, this is quasi-judicial, which means you'll have witness testimony. Because we're having witness testimony and you're making a decision that's a judicial decision in nature, any testimony that someone gives as a witness needs to be under oath. So the board will have the authority to administer oaths. I believe Jane will probably administer the oaths for any witnesses. And typically the way we've done it is everyone who plans to speak comes up at once, and they all take the oath, and then they've been sworn in. But if someone has not been sworn in, they can't give testimony. Y'all also have the authority to subpoena witnesses or compel production of evidence necessary. So if we get into a hearing and a question comes up, well, what does this person have to say, or I need to know the answer to this question, and it's not readily available at the hearing, y'all have the authority to compel the attendance of a witness by subpoena, or to request production of a document, that we want to see this document before we make a decision. Y'all, as a quasi-judicial board, have the authority to issue a subpoena or request production of a document. And if that does come up during the hearing, let me know and we'll figure out the logistics of doing that. But you do have that authority. So once y'all elect from a chairperson, the chairperson will sort of preside over the hearing and perform the following functions. They'll recognize the speakers and members of the board before they can be heard. Essentially, if you come to a board meeting and you've seen how the Board of Commissioners works, it's essentially the function of the mayor. You run the meeting, you recognize speakers, and it's just to provide some sort of order so that not everyone is speaking at once. The chairperson will sort of coordinate who's testifying and who's asking questions.
I have a question.
Yes.
Does the chairperson get to vote?
Chairperson does vote in this situation, yes.
I'm sorry, one other question.
Yeah.
Do they not have a list also of who is going to sign up in advance or not? I noticed in your past ones you did have it.
Typically what we'll do, what's that? We have a sign-in sheet, right. And so, for the most part, we'll know who has signed up to speak. And the way you can do it is if everyone who has signed up to speak, you can ask, is there anyone else who wants to speak or who has information that they feel is relevant? If someone does get up and starts testifying and they're testifying about something that really doesn't have anything to do with what we're here for, the chairperson has the authority to limit their testimony, say, look, what you're talking about now is not germane to the issue that's before us, and we need to move on. So trying to keep evidence in line with the actual thing we're trying to decide. Likewise, they can limit testimony that is repetitive. If 18 people have the same thing to say, you can say, all right, I'll take notice that there's people here who have that opinion. If it's incompetent, and we'll talk about what that means in a minute. It's kind of a term of art in these situations. But it would be something like, if I came up and testified and said, well, I don't know anything about this, but I know that I heard from someone else that this is the case, that's not competent testimony because that's not based on personal knowledge. And so we really do need to keep it as, non-hearsay evidence. Not that we can't have that admitted, but you can't consider that. And if it's incompetent testimony, the chairperson can limit that. Like I said, the board can only consider evidence part of the record. If y'all make a decision as the Board of Adjustment and that decision is challenged, the person who, let's say someone's seeking a variance and they ask for a variance and y'all deny it, they do have the right to appeal that decision to Superior Court. And Superior Court is going to look at that and say, okay, let's look at the record. What's in the record? Does the record support this decision? Is there anything in the record that shows that the decision was made for the wrong reason? And so because someone might be looking at that record and trying to decide if y'all made the right call as a board, we need to make sure that all that evidence gets into the record and that we're not considering evidence that's not in the record. So someone looking at it 3, 4, 5, 6 months down the road needs to be able to look at the record and say, okay, here's why they made the decision they did. All right. So who can appear, who can testify before the Board of Adjustment? Certainly the individual who's applying, if someone's asking for a variance, they have the right to testify. The property owner, if, for example, this is a lease situation and the property owner wants to speak, but is not the actual applicant, whoever owns the property has the right to speak. They have the right to speak for themselves or through an attorney. Sometimes people will be represented by an attorney at these hearings. Sometimes they won't. If an applicant does have someone who they say, I want this person to speak for me, this person represents me, but they're not a lawyer, y'all have the authority to grant or deny that request. One exception to that, corporations or business entities. If it is a corporation, not an actual person who's the one applying, they have to have an attorney speak for them. They can't have the head of the corporation or a non-attorney representative. They have to have an attorney speaking on behalf of a corporation or business entity. Y'all might hear from expert witnesses from time to time if there are particular issues before y'all that require expert testimony, such as traffic patterns. If traffic patterns are going to be affected by this, I can't just come in and say, I don't think traffic is going to be affected, or I think traffic will be affected in this way. You have to have someone who's competent to testify to that, like a traffic engineer. So in certain situations, and we'll sort of, a lot of this is a broad overview. We'll sort of get to, as they come up, issues like that. But just so you know, some testimony is going to require expert testimony, which just means someone trained or experienced to the extent that they can offer an opinion on something that a layperson would not be able to offer. All witnesses, including expert witnesses, should be sworn in. We talked about that. Got a couple blank pages maybe? Hang on, technical difficulties. Y'all have the packet in front of you. Let's just go on with that for now. All right, next slide is about expert witnesses. So expert witnesses may provide opinions and conclusions which require particularized knowledge, like I said. A primary example of that comes up in these situations, like I said, is traffic patterns and stuff like that. There's, by statute, by 160A 393K, expert testimony is actually required to establish sufficient evidence of the following. One, the use of property in a particular way would affect the value of other property. So if someone comes in and says, if you allow this, my property value is going to go down, you actually have to have an expert testimony on that. You can't just say, have someone come say that. You have to have some expert opinion on that. Like I said, the increase in vehicular traffic resulting from proposed development, whether that poses a danger to public safety or not. Lots of people have an opinion on that. Only an expert is competent to testify on that. And then they have got a catch-all, as they do in all these statutes, matters about which only expert testimony would generally be admissible under the rules of evidence. So that's kind of not defined, but if it's something, and we'll know it when we see it, and I'll help you make that determination. If someone comes in here and says something that really a layperson would need training to be able to testify to. All right. Witness examination. So y'all, as the Board of Adjustment members, will have the opportunity to ask questions of witnesses or to cross-examine witnesses. Again, like I said, you can only make decisions based on the evidence in the record, so it is very important that if you do have questions, if there's information you feel like is not in the record that you need to make the decision, it's your job as Board of Adjustment members to elicit that testimony, ask for those documents, get that information in the record. If it's not in the record, you can't use it. There we go. Okay, thanks. Okay, appeals. So, like I said, town administrative officials, for example, Chancellor, often make decisions regarding zoning or enforcement of town ordinances. So, you know, every day decisions are made that are applying a town ordinance to a zoning issue, that those regulate land use or development. Under certain situations, citizens who wish to challenge those decisions can appeal to y'all as the Board of Adjustment, and y'all are authorized to hear these appeals. And like I said, your job in an appeal situation is to decide, did the town make the right decision? Did they correctly apply the ordinance that they were applying? So it's not second guessing. It's not saying, well, I would have done it different. I think this is a good use of property, not a bad use. That's not what this is. This is taking the ordinance as applied by the town staff, and saying, did they make the right call applying the ordinance to the facts at hand? So you're really just acting as a sort of a court of appeals on that. You're looking at whether they got the right application to the ordinance. So who can appeal from a zoning decision? If you look at section 102A, 1705B, that lists the individuals who can appeal. And that's, if you're looking at your Board of Adjustment packet here. Let's see. So only persons with standing under this statute or this ordinance can appeal. Y'all don't hear appeals related to building code violations. If there's a building code violation appeal, that goes to the Department of Insurance. So, and the ordinances we've adopted here mirrors the statutory language. The way we crafted this ordinance was essentially taking the statutory language and putting it into our ordinance so that we adopted the same thing.
Can I ask another question?
Yes, please.
I'm bad. Here it says they appeal to the Board of Commissioners, but way back here you said they appeal to the Superior Court. I'm confused.
Right, okay. Two different types of appeals.
Okay.
So an appeal to the Board of Adjustment is, like I said, town staff makes a zoning decision. We've got code of ordinances. Town staff looks at the code of ordinances and applies that to whoever's, whatever is before them. If someone appeals from that decision by the planning department or whoever it may be, they can then appeal that town staff decision to y'all as the Board of Adjustment. Separate appeal is if y'all as the Board of Adjustment make a decision and the applicant to the Board of Adjustment is unhappy with the decision, or someone else with standing is unhappy with the decision, they can appeal y'all's decision to Superior Court. So there's sort of two levels of appeal there. One is appeal by the applicant from town staff decision to y'all. If they're unhappy with y'all's decision, and this applies to appeals, variances, any of them, if they're unhappy with y'all's decision, they can appeal your decision as a board to Superior Court.
So when does it go to the Board of Commissioners?
I'm sorry?
When does it go to the Board of Commissioners?
Hang on. Does it say Board of Commissioners? It probably should say Board of Adjustment. Yeah, it should say Board of Adjustment.
Okay,
That was a
that
typo.
was my
Apologize
confusion.
for that. Any other questions? All right. So who is allowed to appeal? Someone who has ownership interest in the property owner, leaseholder, tenant with the right, some sort of right. The applicant before the decision-making board whose decision is being appealed, someone who will suffer special damages as a result of the decision being appealed. And special damages is, again, a term of art. That doesn't mean I don't like the decision. That means I will be out of pocket some amount because of this decision, not just I'm going to have to look at this property. It's got to be special damages. Pre-existing association, which is organized to protect the interests of the local area, like a housing, like a, neighborhood thing. Or a city whose board has made a decision the council believes improperly granted a variance or made a decision consistent with the city's ordinance. All right, so time to appeal. Town official making the final decision shall give written notice of the decision to the owner of the property and the party who sought the decision. This is going to be before it gets to y'all. Then the owner of the other party has 30 days to appeal from the town's decision to y'all appealing that decision.
I have a question.
Yes.
So, the owner of the property is the one who gets the written notice,
Generally, yes.
okay? And then it says the owner or other party has 30 days to appeal. Now, in the terminology of the other party, is that referring to somebody who's unhappy with the owner's position, or is that somebody acting on the owner's behalf?
So I think other party in that sentence is referring to these people. Someone who has standing to appeal. So if it's the property owner, they have standing, or if it's someone else who has standing to appeal under our ordinance. But it can't just be someone who, lives across town and is just unhappy with that decision. They've got to have standing. All right, so if y'all are doing an appeal, similar to how a record on appeal is built, when y'all hear something, a record on appeal will be, a record is built with any decision that the town staff makes. If an appeal is made, then that record that consists of the documents considered, the application, anything else that may be pertinent, will be transmitted to y'all for your hearing on that appeal. In other words, you'll get a packet of information that is, here's what was considered, here's the ordinance, here's the application, here's the documentation, and that's the record. That will be transmitted to y'all. When you're hearing something on appeal, you really don't get new evidence. Unlike in a hearing where someone's asking for a variance and you're taking live testimony, an appeal is limited to only the matters considered below. Because again, what you're doing is taking the ordinance that the town staff applied and the application and what was before the town staff and saying, did they make the right call or not? So you're not going to be in an appeal situation getting new evidence to consider. You're considering, based on the record that was before town staff and the ordinance that was being applied, did they make the right call? So stay of decision, y'all don't need to worry about this as much, but when someone does file an appeal, that's going to stay enforcement of the decision until the hearing can occur, unless the stay would cause imminent peril to life or property, violation is transitory in nature, or if the stay would seriously interfere with the enforcement of the ordinance. So that's not something that y'all necessarily need to worry about, but you should be aware of it, that if something is appealed to y'all, that generally stays the matter enforcement of the matter until y'all have a chance to hear it. If the enforcement has not stayed for one of those reasons listed in the first bullet point there, the aggrieved party can seek a restraining order to enforce a stay and may request an expedited hearing, which would only concern y'all if we had to get an expedited hearing and we really just needed y'all to get together quickly rather than, you know, at everyone's leisure. We'd have to say, okay, we got to have a hearing in the next 15 days, and hopefully we can find 5 of y'all, including alternates, that are available to do the hearing. But mainly just for y'all's knowledge that when an appeal occurs, the matter is generally stayed until y'all hear it. All right, so on hearings on an appeal, the town official who made the decision will be a witness, generally going to be the first witness. The appellant can present issues outside of the notice of appeal. So, for example, if they appeal and say, I think they misapplied subsection C of this ordinance, and they come to the hearing and say, you know, I also think they misapplied subsection B, that's okay. They can present issues outside of the notice, but the hearing may be continued if if any party, including the town, would be prejudiced by hearing additional matters. So that's really sort of discretion of the board. If some new item is brought forward on appeal that's not in the initial notice, y'all can say, well, we want to give everyone time to respond and get documentation together on that alleged violation as well. So what can you do on an appeal? You can affirm, which means I agree, the town staff got it right, they applied the ordinance correctly, we're going to affirm the decision. You can do that in whole or in part, which means you can say, I think they got it right on this part, but not on that part. And you may modify the decision. So you can say, I think they misapplied this, and I think what they should have done was this. Decisions on appeal are made majority vote. So if we've got 5 of y'all hearing it and 3-2, 3 agree on one that it was wrongly done, and 2 think it was done correctly, the 3 wins. That's just a simple majority on that. All right. Any questions on appeals from staff decisions? Okay. All right. Next one we're going to talk about is variances. Again, like I said, variances are where no question that the ordinance was applied correctly, no question that they don't meet the ordinance. What they're saying is unnecessary hardship, and both of those words are important. Unnecessary hardship would result from carrying out the strict letter of a zoning ordinance. So they're saying if you apply this ordinance to me as written, it's not fair, in other words. The applicant for a variance may submit reports, arguments, proposed findings, or other documents along with the application. So what must be shown in order to grant a variance? They have to show unnecessary hardship. Now, that doesn't mean that they can't make any use of their property if this variance is not granted. It doesn't require them saying, I can't build anything, I can't do anything. It's less than that. Hardship results from conditions particular to the property, which is important. Hardships that result from personal circumstances or which are common to the neighborhood as a whole or general public cannot be considered. So it has to be something that is related to that piece of property itself, not who the owner is, but the actual property. If it's something that everyone has in common, like I want to build this in this area, but the zoning for this whole neighborhood doesn't let me do it, and I would like to build this here. If the person next door could make the same argument, or the person 2 doors down can make the same argument, that's not a condition particular to the property. That's something that's in common with everyone. And also that the hardship did not result from actions taken by the applicant. So this comes up, for example, if the applicant submitted something to the town that had an error in the way they drew the map, and they ended up building something that was, for example, in the buffer zone that they're not allowed to build, and they're now in violation. And they're saying, look, you know, it was a mistake. We had the wrong information on the map that we submitted to the town, and now I'm out of compliance. It's a hardship on me to redo this. Well, unfortunately, that resulted from an action taken by the applicant. If they submitted incorrect information, then a variance really isn't appropriate, unless there's some extenuating circumstance that is not their fault. But just as by way of example, if something that they did is what's causing the hardship, you can't really grant a variance under the statute. And then, of course, the requested variance is consistent with the spirit, purpose, and intent of the ordinance. What does that mean? That's a little bit vague. But whatever ordinance you happen to be applying, you know, is what the person who's requesting a variance asking to do so out of character or out of whack with the ordinance that it really is not even consistent with what the ordinance is attempting to do. So in order to figure that out, you really have to see, okay, what is the purpose of this ordinance? What is the town trying to accomplish with this particular requirement? And is what they're asking to do consistent with that? Even if not in the letter, then with the spirit of the ordinance, that it's not inconsistent with what the town is trying to do with the ordinance. All right. Special use permits, those can be granted only as permitted in section 102A 403 as special uses. We've got sort of a matrix that sets forth what those are. Application for a special use permit has to go through a particular path. It gets submitted to the county planning staff, who will schedule the application to be heard by the board. So if someone is requesting a special use permit, they go through county staff. The board will consider the application, the site plan, and any other evidence presented, and may grant or deny the special use permit requested. In order to grant a special use permit, this is what you need to find. So if you have a special use permit application before y'all, you need to find that the proposed use will not materially endanger public health or safety, that the use meets all required conditions and specifications, that the use will maintain or enhance the value of adjoining or abutting properties, or that the use is a public necessity. Now again, if you're talking about the value of adjoining or abutting properties, you really need expert testimony to establish that. If they cannot establish that the use will maintain or enhance the value, they can still meet that prong by showing that the use is a public necessity. And then finally, that the location and character of the use will be in harmony with the area where it is located and in general conformity with the town's adopted land use plan. So those are the things that you have to find. If you find that one of those four is not met, you cannot grant the special use permit. You may also consider these factors. These are not required to be found, but there are things that you may consider in deciding whether you grant or deny a special use permit. That is compatibility with surrounding neighborhood, the comparative size of proposed structures in relation to the surrounding area. You know, are they building a gigantic house in a or are they proposing to build a shopping mall in a residential neighborhood or something like that? Frequency and duration of activities, special activities, and the impact of these activities on surrounding area. The capacity of adjacent streets to handle the increase in traffic. Again, that would require expert testimony. The added noise level that would result from the use. The requirements for public services. Are we going to have a lot of police presence required? Are we going to need, is the fire department going to need to come out there a lot? What public services might this use require? And the effect on the general appearance of the neighborhood. Now again, these are things that are not required for you to consider. They're things that you may consider in deciding whether a special use permit should or shouldn't be granted. A couple more. Impact of night lighting and its impact on the neighborhood. Are they going to have night events at whatever they're proposing? The impact of landscaping versus the use of buffers and screens. Impact of hard surface areas in terms of noise transfer, water runoff, and heat generation. Are they proposing to pave something where it's going to create more noise or more stormwater runoff? Those types of things. The availability of public facilities and utilities. harmony and scale, bulk coverage, function, and density, and compliance with developmental standards, and the reasonableness of the request compared to the purpose and intent of the land use plan, town ordinances, policies, physical development of district, and protection of the environment. All of those are a little bit, non-defined. They give you a little bit of discretion in how is this going to impact the community? Is this a good thing or a bad thing? But you have to consider it in the lens of these items and the ones that we talked about previously. If you decide to grant a special use permit, you may impose conditions on that special use permit, which means that, yes, we'll grant you the special use permit, but you have to also do this. So the board may impose reasonable terms and conditions as it deems necessary for the protection of public health, general welfare, and public interest. Any conditions imposed shall be entered into the minutes of the hearing and placed on the permit and approved plans. You can't decide later that you want to add a special condition. You have to do that at the time, at the meeting, and it's got to be put on the record. Such conditions shall run with the land and be binding on heirs, successors, or assigns. What does that mean? That means that whatever special use permit you grant, the applicant, him or herself, isn't the only one that's got to apply with those conditions. If they sell the property tomorrow, that condition runs with the land, not with the owner. So whatever condition you put on a special use permit follows the land if title is transferred from person to person. If any condition imposed is found to be illegal or invalid, the special use permit itself is null and void and the process is restarted. What that means is if you put some condition on the property that a court later determines you didn't have the right to do that, they don't get the special use permit without that condition. They have to start back over through the process because presumably you wouldn't have entered the special use permit without that condition. So if you put a condition on the special use permit and they appeal that condition to court, the court may or may not, if they decide that it's not a valid condition, then we start the process over. Yes?
So you kind of skipped off over that one bullet there. The special
Which one?
use permit is good for 1 year unless otherwise specified.
Right.
But the condition for the special use permit runs with the land.
Right. The special use permit being good for 1 year means, so let's say that you grant a special use permit to build something. That means they can't hold on to that special use permit for 20 years and then say, all right, now I'm ready to build. They have to take action on the proposed use within a year.
So once the build happens, then it's run with the land.
Right. And Chancellor, do you want to add?
That's correct.
Yeah.
They're basically talking about the approval of the special use permit is for a year. You can't hold off one moving forward with the development after 1 year. So it's being approved.
Can you ask for an extension on that? Or do you have to go back through the whole process again?
Mhm.
So the county ordinance reads, once they record that special use permit with registration, they're good to go for the life of the property. And the conditions you're talking about would be specific to that special use permit. So the
Mhm.
conditions do run with the land, but only when that special use permit is used. So if they don't use special use permit, the conditions don't apply.
Okay. So it's after the modification's
Yeah, the
been made.
condition that you all are making will be specific to that special use permit, not to the property.
Right. As always, the answers are always going to be in this ordinance. And I think what it says is the expiration, any special use granted becomes null and void if not exercised within the time specified in such approval, or if no date is specified with 1 calendar year. Once the certificate of occupancy has been issued for a special use and then the special use ceases to exist for a time period of 1 calendar year or more, a resubmittal of the special use application may be required. So I think by virtue of our ordinance, that special use, if they waited longer than a year, would expire, be null and void. And I don't see in here that we have the authority to extend that period of time, unless y'all think otherwise.
Oh, no, y'all can just word it different than the county. The county specifically says once it's recorded with the registry, so it's just different too.
Yeah.
Our statute says that you can't. Like 1 year.
We can't hear you.
What she was basically saying is once it's recorded, then with the county, you can continue to move forward. With ours is worded where it's tied to that 1 year expiration period. So if they don't move forward with it, and they don't start it after a 1 year of it being approved, then it's pretty much null
So
and
it's just
void.
starting it, so as long as you started it within that 1 year, it could last you 10 years till you got it finished, but as long as you started it within that 1 year, then you're good.
No, my interpretation is you have to actually move forward with a building permit, get it open, get a certificate of occupancy within that 1 year.
So you have to-
If that 1 year is coming to an end and you hadn't started it, I don't see anything in our ordinance that allows you to extend that period. There are some periods where if you got a site plan approval or something like that, you can extend that. But for the variances and special use permits, if that 1 year appears to be running out and you hadn't started and you don't think you're going to meet that 1 year period, there is no option in our ordinance to get an extension of that 1
So
year.
how does that work for that TJ Robinson Life Center? Weren't they given some kind of?
That wasn't approved through a special use permit. That was approved through a rezoning.
Okay.
So that's a different set of rules.
Now, with that said about the extension of the 1 year, the remedy would be for them to come back to the board and say, okay, my special use permit is expiring. I would like another special use permit for the same thing.
But then the board has the opportunity to consider
You could
why
you restart it
they've
really.
not done anything.
And another thing I want to highlight, point out too, that clause does not mean that they have to come in every year and get a renewal. So once they get it open, it's open. So that doesn't mean every year they have to come in and get another sign off.
And
But it
can we-
has to be completed within the year.
It basically has to be open within that year. What I'm saying is after they're open, after they gotten the certificate of occupancy, they don't have to come in every single year after that to get another sign off. I just wanted to make sure that that wasn't interpreted that way. It's not a question you guys asked. I was just saying that in addition to that, that's another interpretation that we do have.
And can you introduce this young lady to us?
Hi, I'm Betty. I'm the county planning staff that works
Hi,
with
Betty.
King Chancer in the county department. You'll have to forget my face in about a month though, because somebody else from the county will be here. But somebody from the county planning staff will be at every board of adjustment meeting as well.
Oh, cool, okay.
All right, so if you're considering a special use permit and you decide to deny the special use permit, you got to enter the reason for your denial in the minutes. Because a court looking at it down the road has to know, well, why was this denied, in order to know whether it was properly denied. So once it is denied, you can't reconsider the application unless there is a substantial material change. In other words, it's a different thing. They're doing something different concerning the property or the application. If the plans that they submit are modified, the board shall review any change in site plan submitted as part of a special use application and may impose new conditions if appropriate. The county planning and town staff may approve minor modifications provided the changes do not materially alter the original plan. So if y'all grant a special use permit and going through the process, they say, you know what, we need to change this little tiny minor thing, county planning and town staff can approve that without y'all having to reconvene to approve that. But if it's a material change, y'all get to rehear it and it may impose new conditions based on the change. Compliance, of course, if you grant a special use permit and if you put conditions on it, compliance is an essential element of the validity of a special use permit. So if the chief building inspector determines that the applicant is not in compliance with the special use permit, it comes back to y'all for consideration of whether to revoke the permit based on non-compliance. And then the issue before you would be, are they complying with the permit or not? All right, interpretations. As the Board of Adjustment, y'all are authorized to interpret the zoning map to pass upon disputed questions of lot lines and boundary lines. So let's say two adjoining property owners can't agree on where the boundary line is. Y'all can hear that dispute and make determinations on where the actual boundary line is. The application for an interpretation has to contain sufficient information for y'all to make that interpretation. So if it's just two people come in and say, we can't decide, and, we don't have any information for you, we just want y'all to make a call, you can't do that. They've got to submit enough information for y'all to do that. All right, so when interpreting an ordinance, how do you interpret it? What meanings do you give certain words? So the main goal in interpretation of an ordinance is, of course, to give effect to the intent of the legislative body that enacted the ordinance. Here, for the most part, that's going to be the Board of Commissioners. So you got to figure out what was the intent of the board in enacting that ordinance, and your goal is to give effect to that intent. So absent a definition in the ordinance, so if there's a word in the ordinance that for some reason we're trying to decide what does that word mean, you normally just give it the plain meaning. Everyone knows what that word means, and we're interpreting it in the plain meaning of the word. Ordinances should be construed as a whole. That means you don't take one sentence out of an ordinance and say, okay, reading this sentence, it means this. You have to read the entire ordinance as a whole to determine the intent of the ordinance. One sentence in an ordinance taken out of context that's not proper ordinance interpretation. And of course, ordinances should be interpreted to avoid absurd consequences. So if reading it by the letter gives some crazy result, that's really not proper interpretation. If there are conflicting provisions in an ordinance, let's say there's two different ordinances that say two different things. Well, if they can be reconciled, we got to figure out a way to reconcile them so that they both have in effect. If they're very clearly contradictory and they cannot be reconciled, then the later adopted ordinance controls. When an ordinance is read to restrict property rights, that restriction must be clearly included in the ordinance. So we can't imply restriction on a property right. It has to be pretty well set out in the ordinance that it is intended to do that. And I'll be here at these meetings to help with issues that arise in this regard. All right, in interpreting the map or whatever, if uncertainty exists, boundaries indicated as approximately following center lines of alleys, streets, highways, streams, or railroads shall be construed to follow the center lines. Boundaries indicated as following lot lines, town limits, or ETJ boundary lines shall be construed as following such lines, limits, or boundaries. Boundaries indicated as following shoreline shall be construed as following such shorelines. That'll make more sense if you have a boundary dispute before you.
Question.
Yeah.
That ETJ that you said, that's extra.
Extraterritorial jurisdiction of the town, yes. All right, where a district boundary divides a lot, or where distances are not specifically indicated on official zoning maps, the boundaries should be determined by measurement using the scale of the official zoning map. Where any street or alley is officially closed or withdrawn, the regulations applicable to each parcel of abutting property shall apply to that portion of street or alley added to the parcel by virtue of the closure or withdrawal. As I said, this will make more sense if you're looking at a boundary map and you're trying to determine what. It's a little bit hard in the abstract to get this, but if you're looking at a boundary map, making an interpretation, these will be our guidelines. All right. So if you're considering a variance, there's going to be we've got 5 of y'all and 2 alternates. So 5 of y'all are going to be voting at a time. If you're considering a variance, you have to have a 4/5 vote. That's just by statute. We got to have 4/5 of a vote. All other actions that are not variances, it's just simple majority vote. Vacant positions of the board are not used for calculation of the requisite majority. That means if we've got 3 of y'all absent and we've only got 4 people, you still have to have a 4/5 majority, which would be 4 out of 4. All decisions shall be made within a reasonable time and should be based on competent material and substantial evidence in the record. reasonable time. Normally, decisions are going to be made at the hearing. There may be times where y'all decide there's additional information that we need in order to make a good decision here. And we'll do our best to figure out a way to get that information to y'all in a reasonable time, which is not defined by any particular, set of days or anything like that, but what would be considered a reasonable amount. We try not to take several months to make a decision. The decision is made when it's reduced to writing and delivered to the applicant. So y'all will vote at the hearing most of the time, but the decision is not actually a decision until it's reduced to writing and delivered to the applicant, and of course anyone else who requested a copy. This board is not legally bound by prior decisions of the Board of Adjustment. So just because a different Board of Adjustment, y'all are a new Board of Adjustment, so if some applicant comes in and says, well, y'all have to give me this variance because the last Board of Adjustment did this similar variance request and it was granted, so y'all got to follow precedent. It doesn't really work that way. Y'all are not legally bound by precedent, but similar cases should produce similar results. So you're not legally bound by it, but you should treat that as a pretty good guideline. We want to treat everyone who makes an application to the Board of Adjustment equally. We don't want some people coming in getting variances on a particular set of facts and other people not getting variances based on the same set of facts. That creates a lot of issues. So we want to apply our rules evenly, fairly, and so you should take into account if you are aware of what a prior board did, but it's not legally required. But y'all should try to take that into account. All right. We sort of talked about this already, but quasi-judicial means that y'all are applying y'all are taking the facts as presented to you by the applicant on whatever it is and applying the law to those facts. You don't have authority to modify the ordinance. So you don't have authority to say, well, I know what the ordinance says, but I don't think that reaches a just result. So I think we should change this ordinance a little bit. You got to apply the ordinance as written. Hearings in this, as the board, are akin to court proceedings, which means due process must be provided. I'll talk about that in a second. Board should make factual findings to support its decisions, and those findings should be based on the competent evidence in the record. All right, so what is due process? Due process is anytime there's procedural due process and there's substantive due process. Y'all mainly need to worry about procedural due process. Under state and federal constitutions, any applicant or property owner in this setting has to be provided what's called due process. They must be given a meaningful opportunity to be heard and present testimony and admissible evidence. So if for example, if an applicant comes in and you say, you know what, we've already made our decision, we don't need to hear from you. They have not been given a meaningful opportunity to be heard. So we got to make sure everyone gets a meaningful opportunity to be heard, to present their case, present their testimony, and then once they have done that, we make the decision.
Excuse me, Dan.
Yes?
There's no 3-minute time limit on any of this.
Correct, right. The 3-minute time limit is only for public comments at the Board of Commissioners hearing. There's not a time limit. Although the chairman, like I said, if someone's getting long-winded and getting away from the point, we can refocus and say you need to, get back on track. So a violation of due process could include one of y'all having a fixed opinion prior to the hearing. Like I said, if you come in and said, I've already looked into this, I know what my decision is, you can say what you want to say, but I've got my mind made up. That's a violation of due process. They're entitled to an impartial decision maker on these things. Undisclosed ex parte communications. So if an applicant comes to you and says, hey, I know you're on the Board of Adjustment, I got a case coming up, I don't want to do anything wrong, I just want to let you know I'm coming and here's what I've got and I hope you'll give me a fair chance. That is an ex parte communication, even if they haven't told you anything about the case. And that's something that at the very least you need to disclose and we can figure out how to deal with. Anytime you talk to a party an applicant, a property owner ahead of time, that is an ex parte communication, and you should do your very best to avoid those. If you do have one, if someone comes up to you and says, hey, I look forward to seeing you at the Board of Adjustment hearing, I got a variance coming up, then at the very least you need to disclose that, and we can figure out what to do with it. If an applicant is a close family member, business acquaintance, other relationship, y'all know this person, if they're your next door neighbor, that should be disclosed so that we can decide if you've got a conflict. It's one of the reasons we have alternates, is if there is a conflict and you can't hear a case, then one of the alternates can step in. And obviously, if you have a financial interest in the outcome, you really can't be an impartial decision maker. Like I said, any potential conflict or issue, even if you don't think it's a big deal, should be disclosed, in fact, must be disclosed prior to the hearing. It may not be a big deal. It may be something that doesn't disqualify you from hearing the case, but we need to know about it so that we can make that decision. All right, let's say y'all make a decision and after the public hearing, you find out something and you say, look, we need to change that. The board can reverse a decision after public hearing in the following situations. If you find out the approval was obtained by fraud, if fraudulent documents were submitted to y'all and you made your decision based on those documents. The use for which the approval was granted is not being executed, non-compliance. Use for which approval was granted has ceased to exist or has been suspended for a year or more. Permit is being exercised contrary to the terms and conditions of the approval or in violation of regulation or statute. Use for which the approval was given is detrimental to public health or safety or constitutes a nuisance. So in those situations, y'all can consider reversing your decision. Like I said, all of y'all's decisions on any of these things are quasi-judicial, and they may be appealed to the Superior Court by filing a petition under 160A 393. Because of that, that's why it's important to build the record. So as you go through a hearing on whatever it is, like I said, your job as Board of Adjustment members is not only to make a decision, it's to build the record. And that means asking the questions to elicit the testimony that you feel like is necessary and pertinent to making the decision, and to asking for the documents that you feel like you need to see in order to make the right call. Because the court's going to be looking at what we did down the road, or may be looking at it, and we want to make sure that we've done it in the correct way and gotten everything that we need to get into the record. Any questions for me? All right. Again, thank y'all for being willing to serve, and look forward to working with y'all.